Nigerian prisons are collectively reported to hold over 60,000 inmates, with about 70% of this number awaiting trial. Congestion at the prison is one of the several challenges the nation's prison service is confronted with, given that the wheels of justice turn slowly with increasing litigation arising from the inevitability of disputes amongst individuals and groups. Interestingly, litigation, which has become the norm in resolving dispute despite its consequences of high cost, delays and complexities, has not always been the way to go. Records abound of a more accommodating system adopted in pre-colonial Nigeria, which preserved the relationship of disputants, a system which is gradually staging a comeback in the form of alternative dispute resolution, or ADR. With arbitration and other forms of ADR receiving constitutional backing, yet court cases are on the increase, what readily comes to mind is the viability of this method and the level of awareness and acceptance by disputing parties. The Gacaca alternative adopted to settle disputes arising from the genocide in Rwanda readily comes to mind. Operating within the framework of a nominal winner in a dispute, often the real loser in terms of fees, expenses and time, the Dateline 360 team x-rays the ADR and how it can assist the judicial process. It's good to have you join us this week. As always, I'm Hawa Salihu Adama. It's Dateline 360. Thanks for rejoining us. Our concern this week is putting to test the statement that judgment is not synonymous with justice, which is what one sometimes gets in a litigation. What then are the alternative methods of resolving disputes and how viable these can be are some of the questions Dele Atumbi tries to answer in our lead report.
In the day-to-day interaction of man, in all aspects of life, there is bound to be conflict as a result of differences in interests, goals, as well as means of achieving such goals. It is in the light of these that laws are enacted to guide the interaction of man with the aim of evolving best practices to reduce conflict. It has been asserted that as long as there is interaction among man, there is bound to be conflict, and such conflicts are meant to be resolved. Hence, the establishment of the legal system of a sovereign country to avert disputants resulting to jungle justice or self-help. The legal system of a nation, to a large extent, is influenced by its colonial administrators. For instance, in Nigeria, the colonial masters bequeathed to the people the English legal system, otherwise known as common law, with all its technicalities and bottlenecks resulting in delay in access to justice. Before the advent of English legal system in Nigeria, Nigerians, like other Africans, had a way of resolving disputes which is being referred to today as alternative dispute resolution, ADR. It is pertinent to point out that in Nigeria's pre-colonial society, disputes were resolved by respected members of the society or by the traditional ruler, ably assisted by his council of chiefs.
The concept of ADR, that's alternative dispute resolution, is nothing new when it comes to African perspective. It's been with us since the time of our forefathers.
This kind of dispute resolution, later being referred to as customary arbitration, which was relegated to the background due to the advent of litigation, is similar to the modern-day alternative dispute resolution. Alternative dispute resolution is a term used to describe several methods of resolving legal disputes without going to court. Section 19 of the 1999 Constitution, which is the ground norm of the Nigerian laws, provides for the use of alternative dispute resolution mechanisms like arbitration, mediation, and conciliation in resolving disputes. Some courts, in their practice directions, encourage alternative dispute resolution through the multi-door courthouse concept as a way of preserving business relationships. In line with our Supreme Court judgment, the use of alternative dispute resolution in resolving matters is a precondition to approaching the court for litigation in some cases. For ease of doing business today in Nigeria, alternative dispute resolution mechanisms are imputed in the clauses of some contracts of resolving commercial disputes.
In some places, there's even a taboo for you to take your wife, your husband, your family, even your business partner to court, because like Yoruba, they will tell you, we cannot leave the court and we now remain friends. All these things, people just believe that since I still need to do this, why not let's go to ADR?
Over time, we have found out that the court system takes extremely it takes a very, very long time. Alternative dispute resolution has come to stay, and we businessmen, we opt for that.
As a way of taking care of the interests of the enrollees under the National Health Insurance Scheme, the Act establishing the scheme provides for the establishment of Health Insurance Arbitration Board in all the states of the Federation, as well as the Federal Capital Territory.
Apart from decongesting the courts, what are the other advantages of alternative dispute resolution?
It's certain. People always believe that, no, it is more normal to do that than going to court, because going to court is like that is the final way of settling dispute.
One, their trade secrets will be well protected, and the kind of figures at times that will be mentioned in the business deals, they may not want this kind of thing in the public domain. Trade reputation. The moment people get to know that, oh, this company is in this litigation, very hostile litigation, especially the financial industry, it may lead to a kind of a run on that institution.
Arbitration and Conciliation Act and the Trade Dispute Act also encourage the use of alternative dispute resolution in labor matters.
Because the workplace it's like a family. You have the employer, you have the workers, and therefore any dispute that arises, the quicker the resolution of those disputes are made, the better for everybody.
To strengthen the mechanisms, experts are evolving in the fields of arbitration, mediation, and conciliation. In the final analysis, alternative dispute resolution is the modern version of an ancient practices which is being encouraged in various jurisdictions all over the world. For Dateline 360, I am Dele Atumbi.
Ancient practice, many say, deserves not only a comeback, but Rofia Animation Badmus is our guide.
Dispute resolution has been part of the culture and tradition of the people of Yoruba land in southwest Nigeria. The system of living of the people recognize the possibilities of dispute and effects on the generality of the people. As colonization set in and courts provided alternative dispute resolution approaches still stay.
In Yoruba land, it is believed that parties in conflict cannot settle their matters in court and still remain friends. But because humans interact with one another every day, dispute has been and will always be part of human existence.
As a result of this, strategies have been put in place to alter or de-escalate conflict through various means of alternative dispute resolutions. Among disputes recognized by the system are intra-family, inter-family, individuals, land and inheritance, and communal and intercommunal.
There are situations where people are expected to swear, before starting the process, swearing, saying that everything that I'm going to say, would be true. I'm not going to deceive elders. And in some cases, when the conflicts are settled, you might be expected to do a number of things that supports reconciliation, which many of us in the contemporary settings will not do. Nowadays, when elders are trying to settle a conflict, rather than actually going to traditional religion by saying, let us start with some religious rituals, the elders might just say, let somebody here give us a prayer before we start this process.
Mechanisms put in place for dispute resolutions include heads of family, peace committees, palaces, and highly respected individuals in the society.
You imagine those days, they will put a calabash down, and inside the calabash some leaves, and we call somebody who had offended somebody or who had killed somebody, and you will see the person coming out of that calabash and talking. It's not fiction. If our people had been developing this and writing it down, we had our own television. That is television. But that's a way by which we solve problems, that problems are solved in those days.
The traditions are there, but the traditions are saying we must respect our elders, not only just showing respect for what they say, but when they intervene in our conflicts, we should consider their age as being important.
Interventions by these recognized individuals and institutions through mediation have assisted greatly in resolving many disputes, including the age-long ones, as the decisions, which are mostly win-win, are recognized and accepted by parties in disputes.
They used to have in the compound system, for instance, where I came from and from and other Yoruba families, they call it Ile Igbejo, which you can say is the equivalent of a court. So they will sit. Then they will invite the litigant, complainant, and the respondent. State your case. And you will state your case back with evidence and witnesses. Then the elders will now meet, resolve. Sometimes they will ask the complainants and the respondent to please excuse them and go out. Then they will pass a judgment, which will be read by the Magaji or anybody he chooses, and that will be final.
It is when all efforts at resolving disputes through alternative means failed that parties can go to court. This is, however, very rare. Wofia Animashambadi.
Very interesting perspective from Nigeria's southwest, I'd say. Also, we can have peace. And from Yoruba land, we move to southeast Nigeria, where Susan Eze takes us through the various methods of maintaining peace and order, with specific focus on the role of the daughters of the land, known as the Umada group.
Most African communities, such as the Igbos of the southeast Nigeria, have institutions and procedures set up for peaceful resolution of conflicts. These authorities include family heads, traditional rulers, council of elders, age grades, married daughters of the land called the Omuada. In extreme cases, disputes are taken to the village deity or oracle for resolution.
In most parts of Igbo land, the Igwe's palace is like a traditional law court where cases that have gone beyond the families, the clans, are taken to Igwe's palace for the Igwe and his cabinet.
Where they fail, they will take the matter, they will return it to the traditional ruler, who assembles his cabinet and elders of the community to determine the matter.
Although police and court actions are common features in today's society, many communities in Igbo land still revere the authority of these traditional institutions as an alternative instrument of conflict resolution, particularly the Omuada group.
Wherever they are married, they normally think of their father's place and do make sure that they resolve that any dispute that arises is resolved.
The Omuada or married daughters of the clan are certainly no pushovers. Hence, their reconciliatory role in families and communities is of great importance in the sustenance of peace in Igbo communities. They come from their husband's place to settle issues or to admonish erring wives in their paternal village. They also handle widowhood matters. Their decisions are highly respected.
The Omuadas are more effective in handling it. They can apportion the blames. They can look themselves in the face and say, tell the person who is at fault that is at fault, without actually mincing words. They do that, and they do it effectively.
They are one of the decision-making bodies in communities. And when you talk of conflict resolution, they are most powerful because most times women are not lobbied easily. They are not deceived easily. And when women tell you that they will move mountains, surely they will do that.
However, before certain matters like marital disputes get to the Umuada, it must have been handled by other authorities, such as the family head, who mediates in the resolution of family issues.
In many parts of Igbo land, the traditional conflict resolution institutions, especially the Umuada group, are so strong in what they do. Nobody in that community goes to the conventional law courts without first trying out these options available. If you do, you are fined by the community. That is how strong these traditional institutions are in conflict resolution. In Enugu, Susan Eze for Dateline 360.
Thanks, Susan. I understand in that part of the country, despite the perceived second-class citizen status of a girl child, irrespective of status or gender, the fear of the Umuada group brings one back in line. And to a last report from the zones put together by Muhammad Nasir. Location is northern Nigeria.
In some parts of northern Nigeria, conflict often occur due to some factors such as intolerance, struggle for dominance, disagreement, illiteracy, and failure of governance to deliver the good. The negative consequences of these conflicts from time immemorial necessitated application of various conflict resolution mechanisms by local authorities such as dialogue, committee of elders, and family get-together to settle disputes.
For a ward head, there is a ward head. He's a traditionalist. There is a village head. He's traditionalist. There is a district head. He's traditionalist. There is emir. He's traditionalist. We are working. Even before independence.
In traditional societies of northern Nigeria, like here in Sokoto, for instance, there are various conflict resolution mechanisms that lies in the hands of religious and community leaders who are the custodians of peace and harmony in their society.
Most of the cases we receive here, we resolve. They are far better in population or congestion of people. Too many cases filing before us is even better than in court, and even better than going to also police station or any other. People have confidence that when they address issue, when they report issue to any traditional institution, they have fair hearing.
Islam commands us to make reconciliation between people when there is any misunderstanding among them. Now, the idea of conflict resolution is mentioned in the Quran. Allah says, "La khayra fi kathirin min najwahum illa man amara bi sadaqatin aw ma'rufin aw islahin bayna nas." That there is no any good in the meeting of people except if they do it on some of the other things that Allah mentioned, part of which is to reconcile among people.
In the free modern society in northern Nigeria, absence of social injustice in settling disputes by traditional institutions was one of the qualities that made the system more effective and more acceptable by the people.
Judicial system becomes necessary only if the normal conflict resolution mechanisms within the community fails to work. Preferably, it shouldn't get to that point.
The Supreme Court already even inserted the ADR in the rule of the Supreme Court. Even if the matter gets up to Supreme Court, it can be still settled out of court. The Court of Appeal also did same.
It is still a popular belief that alternative conflict resolution is the best way in handling disputes among communities. I am Muhammad Nasir reporting for Dateline 360.
Well captured, Muhammad. The question remains how many disputants are taking advantage of these methods to save themselves from unnecessary judicial stress. And that's why we asked Aliu Tukur here in Nigeria's federal capital city to speak to those who should know on adopting the ADR on a larger scale.
No doubt, alternative dispute resolution as a legal process other than litigation is gaining acceptance at the highest level of judicial administration. But is this really a venture worth exploring?
Apart from the fact that it is cost-effective, it is communal, it is historical. It has to do with people's sense of community and togetherness. So it is a face-to-face interaction where everybody is equal and people are given equal opportunity.
What checks and balances exist to make this truly an alternative.
We need our lawyers to be trained on the adoption of alternative dispute resolution in resolving disputes of their client. From our own experience, we have discovered that because of the little or no knowledge about alternative dispute resolution, a lot of lawyers have even encouraged their clients to go into court, to jump into court to resolve disputes that could have been easily resolved, and that even the court itself, like what we're having in Lagos and Abuja, what we call the multi-door courthouse, the court itself, the judges should encourage litigants to adopt alternative dispute resolution before they come to court.
The mediation processes, the arbitration processes that are adopted should be transparent enough for the parties that submit themselves to the alternative, to the process, to have confidence in the process. Once there is confidence in the process, it will be easy for citizens to agree to it and submit to it.
The National Orientation Agency, for one, should be the umpire on this movement, trying to sensitize the society so that people will know their left from their right. If I know what I will do to you that will bring dispute and bring conflict, and I desist from it, then dispute is already halted, nipped at the bud.
When awards are made by a panel of arbitrators in alternative dispute resolution, these awards should be enforced and respected. That way, it breeds further compliance.
Considering the fact that alternative dispute resolution is a field developing, the consensus is on the need to create more awareness for it to achieve the desired goal of less litigation and decongestion of the courtrooms and the prisons. For Dateline 360, Aliu Tuku.
More awareness and less litigation, that's the goal, Aliu, considering that win-win is an attitude and not an outcome. Conflict, no doubt, is inevitable, but combat is optional. Though litigation could be described as having the advantage of finality and sanction, sometimes it isn't the case, as business relationships between parties could be permanently destroyed. Alternative dispute resolution tribunals, on the other hand, are notably quicker in reaching decisions. With ADR strategies in settlement of commercial disputes becoming general application in more advanced jurisdictions, the call is for Nigeria to expand its limited scope of adoption of ADR. Courtrooms, rather than the first, should be the last resort. After all, alternative methods of resolving disputes have failed, as in the process, all parties in a judicial process would be better for it. You can, however, share your thoughts with us on Dateline 360 at nta.ng or tweets at NTA News Now. Our last word this week captures the essence of the inevitability of conflicts and the way out. When you are at the edge of a cliff, sometimes progress is a step backwards. Many thanks for your time, and bye for now.